Okay, so we continue with the procedures in tackling environmental crime. So dito na tayo sa bail. Okay, is right to bail available for the accused under these rules in pagtackle nga ng environmental crimes? Well, the answer is yes. Accused for violation of environmental laws can file bail, and he may file bail in the same manner as with other criminal cases. So what are the special conditions for the grant of bail under the new rules? So before the grant of bail, the judge must read the information in a language known to and understood by the accused. I'm assuming familiar na kayo sa term na information. Then the judge shall require the accused to sign a written undertaking which contains the following: that the accused will appear during arraignment and whenever required by the court, that that if the accused fails to appear without justification, to waive the reading of the information, to authorize the court to enter a plea of not guilty in his behalf, and for the court to proceed with the trial in absentia. So, kung wala or kung hindi dumating ang accused sa kanyang uh, hearing, during arraignment rather, um, automatic na ang court na ang magde-decide na ang i-enter niya na plea ay not guilty. Well, in the Philippines, lagi naman kasi tayong in favor of the accused, di ba? Kaya, dun tayo sa kung saan siya mas, kumbaga, alin yung mas magaan para sa kanya. So, not guilty. Kasi nga, innocent until proven guilty naman ng isang tao. Ganun natin siya kinoconsider dito sa Philippines. And then, arraignment and plea. So what is the role of the concerned government agency in plea bargaining? So unlike in ordinary cases, the presence and consent of concerned government agency is required in plea bargaining for environmental cases, such as the DENR, kung involved ang BIFAR, yan, kailangan uh, andun sila. So prohibited pleadings and motions. So the following pleadings or motions shall not be allowed: motion to dismiss the complaint, motion for a bill of particulars, motion for extension of time to file pleadings, except to file answer, the extension not to exceed 15 days, motion to declare the defendant in default, reply and rejoinder, and third-party complaint. So while the enumeration have been adopted in part of the rule on summary procedure in response to the question of delay, which often accompanies regular cases, summary procedure is not adopted in its entirety given the complex and wide range of environmental cases. Take note. Procedural safeguards have been introduced for truly complex cases which may necessitate further evaluation from the court. Among these, the exclusion of the motions for postponement, new trial, and reconsideration, as well as the petition for relief from the prohibition. Then, motion for postponement, motion for new trial, and petition for relief from judgment shall only be allowed in certain conditions of highly meritorious cases or to prevent a manifest miscarriage of justice. Yun lang yung mga pagkakataon na pwedeng mag-grant ang isang motion for postponement, motion for new trial, and petition for relief from judgment. So the satisfaction of these conditions is required since these motions are prone to abuse during litigation. Alam mo yung mga style na ide-delay, ayan nga, ipopostpone, mag-new trial na lang, imbes dun sa present, kasi nga, ayaw nilang maparusahan. Okay? Motion for intervention is permitted in order to allow the public to participate in the filing and prosecution of environmental cases, which are imbued with public interest. Petitions for certiorari are likewise permitted since this raise fundamentally questions of jurisdiction. Under the Constitution, the Supreme Court may not be deprived of its certiorari jurisdiction. Okay, pre-trial. So what are the next steps after the accused is arraigned? So magkakaroon ng pre-trial, trial, and judgment. Well, basically the same lang sa criminal cases, di ba? So ano ba ang pre-trial? A pre-trial conference is a procedural device used prior to trial. Kaya nga siya pre-trial kasi gagawin siya before the trial in order to narrow issues to be tried, to secure stipulation as to matters and evidence to be heard, and to take all other steps necessary to aid in the disposition of the case. So when should the pre-trial be scheduled? So it should be scheduled 30 days before the arraignment. So what happens during pre-trial? Well, during this time, the issues will be identified, marking of evidence to be presented as exhibits, comparison of copies attached to the records with the original documents, stipulation of facts, and admissions. Settlement of the civil aspect of the case, and other matters that may aid in the prompt disposition of the case. Okay. So what is the role of the law enforcer, yung police, during pre-trial? The law enforcer should be present during pre-trial and assist in the identification and marking of sworn statements and other exhibits. Uh, he or she should also inform the prosecutor on matters related to the stipulation of facts and admission. Okay, dito na sa trial. Tapos na tayo sa pre-trial. How long will the trial on environmental cases be held? So the court shall endeavor to conduct a continuous trial which shall not exceed 3 months from the date of the issuance of the pre-trial order. Anong nangyayari doon? During trial, the prosecution presents the evidence and testimonies to prove the guilt of the accused. The defense naman presents evidence and testimonies to show that the accused is not guilty of the offense charge. Basic, alam niyo na to. When should the court decide on the case? The court shall decide on the case within a period of 10 months from the date of arraignment. Okay. In environmental cases, same lang din. Merong iba't ibang uri ng ebidensya. And one of those evidence is documentary evidence. Wala. Ayan. So how are photographs, videos, and similar evidence be admissible in court? So photographs, videos, and similar evidence may be admissible in court authenticated by the person who took the same, by some other person present when said evidence was taken, or by any other person competent to testify on the accuracy thereof. Um, I think sa question documents, na-discuss din natin ito, or sa cybercrime. Okay. So, paano ginagawa ang pag-authenticate? So, it is done by executing a sworn statement in question and answer regarding the circumstances surrounding the taking of the photographs, videos, and similar evidence, and attesting to the accuracy of the same. So, kailangan merong tao na magpapatunay nga, magbibigay siya ng sworn statement or ano to? Kung papaano niya na-acquire yung evidence na yun, kung papaano niya nakita yung ganong ebidensya. So that's for the rules regarding the procedures in environmental cases.